In the High Court of Rajasthan at Jaipur, an urgent writ petition has been filed by the petitioner alleging violation of his fundamental rights under Articles 14 and 21 of the Constitution of India, stating that the respondent authorities have arbitrarily rejected his application seeking renewal of commercial license required for continuing legitimate business operations within the municipal limits without assigning any reason or providing an opportunity of personal hearing to the petitioner despite repeated written requests submitted on several occasions through registered post with acknowledgement. The petitioner contends that he has complied with all statutory requirements, including submission of fire safety inspection reports, environmental clearance certificates, structural stability affidavit, and prescribed government fees within stipulated time. However, the respondent authorities neither processed the application nor issued any deficiency letter, thereby causing unnecessary delay, which resulted in heavy monetary loss and reputational damage to the petitioner. The petitioner had approached the office of licensing officer multiple times, yet the concerned official avoided meeting him and indirectly suggested that the matter could be expedited upon receiving illegal gratification, since the petitioner refused to give any bribe. His application was deliberately kept pending until it eventually lapsed, following which a competitor business establishment was granted license in the same area. The petitioner alleges collusion between the licensing officer and the competitor, stating that the officer misused his official position for personal gain and intentionally discriminated against the petitioner. The petitioner states that withholding legitimate approval amounts to tolerable exercise of power and violates principles of natural justice, especially odi ultrem partem, meaning no person should be condemned unheard. The petitioner submitted a detailed representation seeking review of the matter, but no action was taken, compelling him to approach this honorable court seeking judicial intervention for protecting his lawful rights. It is further argued that the impugned order suffers from non application of mind and is therefore void ab initio, as it does not specify any legal or factual basis for rejection. The petitioner filed a vague reply stating that the petitioner's application was incomplete solely on the ground that an environmental impact assessment was not attached at the time of initial submission. The petitioner clarifies that the said document was not required under the applicable rules for the category of business he operates, and that the said requirement was arbitrarily invented. The petitioner therefore prays for issuance of a writ of mandamus directing the respondents to consider his application afresh within a fixed time frame and in accordance with law. During hearing, learned counsel for the petitioner argued that delay in issuing licenses affects trade and profession, thus violating Article 19, Subclause 1 of the Constitution. The court observed that administrative authorities are duty bound to act fairly and transparently, and that corruption has no place in public governance under the rule of law. The respondents were unable to produce any internal file, noting, or inspection record to justify rejection of petitioner's application, which further strengthens petitioner's allegation of arbitrariness. After hearing arguments, the court directed the licensing officer to produce the entire record relating to petitioner's application, including file movement register, deficiency memos, and correspondence records. During production of documents, it was revealed that the petitioner's application remained unattended for more than 120 days without any official noting or decision, thereby confirming administrative negligence and dereliction of duty on part of responsible officials. On noticing the record, the court issued a show cause notice to licensing officer asking why disciplinary action should not be initiated. Subsequently, the officer filed an affidavit stating that the file could not be processed due to shortage of staff and heavy workload in the department. The petitioner objected, arguing that workload cannot justify violation of statutory duty, especially when livelihood of a citizen is affected by irresponsible conduct of government officers. The court remarked that discretionary power cannot be exercised arbitrarily, and government officers are accountable for their actions when dealing with applications related to trade and commerce. During proceedings, the petitioner produced an audio recording where an unidentified intermediary demanded money on behalf of the licensing officer for grant of approval. The petitioner submitted this recording along with forensic verification request to prove authenticity and substantiate allegation of corruption. The court directed police authorities to conduct preliminary inquiry and submit a status report on possible bribery involved in the administrative process. In cross examination, the intermediary confessed that he had made the demand at the instance of the concerned officer and that similar payments had been collected from other businessmen. Based on the testimony, the court directed Anti-Corruption Bureau to register first information report under relevant provisions of Prevention of Corruption Act 1988. Upon registration of FIR, the licensing officer was placed under suspension pending departmental inquiry, and access to applicant files was removed from him to avoid tampering with official records. The respondent department appointed an independent officer to review pending license applications, ensuring transparency and fairness in the process. The petitioner argued that the loss he suffered due to illegality spans beyond monetary damages and includes mental harassment and damage to business reputation. He requested compensation and exemplary costs to be imposed on the respondents so that such arbitrary practice does not repeat in future. The court acknowledged that arbitrary administrative decisions have far reaching consequences, and therefore government departments must adhere to principles of fairness, equality, and reasonableness.